topic a little bit.
I agree. Let's start there. Morning, everybody. Welcome back. If you haven't been to this class before, I'm glad that you found your way here. Last week, or I guess it was 2 weeks ago, we had a really interesting discussion on the NAR settlement talks and some of the more recent, talk on that and kind of how people are thinking about it. We even had a really cool guest appearance from Mark Hall, who's a president of Atlantic Communities, a big 2,000 agent brokerage up there. So if you haven't seen that video, it's all on YouTube. I put all the videos on YouTube, so you've got a whole host of different things on there. And if you have to cut out of this class a little soon, or if you want to refer back to it later, you can, youtube.com/Christian Ross. So this topic, I thought we would get into more of the nitty-gritty, more of the normal stuff. Everyone's been more worried about whether, how this industry is going to look 12 months from now. But in the meantime, and going forward, we're going to need to know how to do this work efficiently and effectively. And this is something, Dad, that you and I contend with. Mike, you contend with it at your brokerage at Downing Fry all the time. Who signs the listing agreement? How do we set up the buyer? How should they sign their contracts? Mike, this is never a problem for you guys, though, right?
No.
Talk about a loaded question.
Why is this difficult? What are you guys thinking about from the broker's perspective? Are you just in it to give your agents a hard time? Is that what this is all about?
No, honestly, it's as simple as we want to make sure the I's are dotted and the T's are crossed. And you want to make sure that, if the property is owned by a husband and wife, that you have both signatures. If you got one signature, that creates a problem.
Yeah, it's a problem because your business is predicated on having an agreement to sell someone's house. And if they don't have the authority to sell it by themselves, if you haven't gotten the proper signatures, then that agreement is nothing. And now you're working for free, potentially.
Is it bad if I sign my wife's signature to things like this?
What do you think, Mike? How would your broker feel about that?
No comment.
Yeah, let's not do that.
Have you ever signed Ruth's signature, Mike?
So actually, to that point, Dad, you've always had an idea that, get more signatures, not less. When in doubt, put a little bit extra on there. What kind of drives that mentality? What are you worried about, or why is that kind of your go-to?
I encounter people on the weekend who have buyers or sellers who are afraid to sign because they don't know if the right person is signing. And I want to enable the agent to get an enforceable contract. So my philosophy is I'd rather have too many than too little. You can always toss away the ones that are superfluous. It doesn't hold them up until Monday when they can talk to their lawyer and who the necessary signatory is, because then the lawyer is going to talk the person out of the deal or add things to it. We lawyers tend to do that. So it's just an aid to the realtor to get a signed deal on the weekend. Just get everybody.
Yeah, and you guys have probably, been in this scenario where you're trying to get the listing secured or you're trying to put a contract together and you think the husband's the only one on title. It looks that way when you pull the deed,
right?
But the wife is right there. And you're thinking, well, I really need to double check. Do I need the wife? Do I not? What we typically might want you to do is just, if they're both there, have them both sign.
Have them both sign. What if they made it Homestead yesterday?
Yeah, it doesn't hurt to have more signatures than less. I agree.
Just because they didn't do a declaration of Homestead doesn't mean it's not Homestead. So
right.
Get her to sign.
We always talk about bottlenecks. I don't want the bottleneck to be at that moment when they agreed to sign with you. I don't want you to hold the train up right there, because then it puts your whole business in flux. I want you to get that signed and then warn them, hey, look, I'm going to have this reviewed on Monday by the broker and by the attorney. If for any reason we need to do it a little differently, I'll come back to you before it's fully executed or something. You could do that.
I'm worried about buyer's remorse. Sellers as well. I mean, they're all excited in the moment, get everybody to sign when they're oohing and ahhing over the property. And, the next morning when they have their buyer's remorse, it's too late, they signed.
Yeah. So practically speaking, we want more signatures. If they're there, have them sign it. And then, you know, the other part of it, and this is something I've dealt with myself. I remember the very first closing I ever did. I was working for a national title company based out of Ohio, and I was in Atlanta. And what they had me do is I would go to people's houses and sign up a new mortgage with them. And so I didn't know who these people were. I didn't know the file. It was just a refinance that someone in Ohio did. So I'd show up, and I remember the very first one, I showed up at like 8 o'clock. The guy had been working all day, and he was the only one on title, but they had his wife signing everything. All right, and you know what it was? They were both on title, but the wife was not on the mortgage. She was not on the note. So I'm
Yeah.
sitting down, we go to the first page, and the husband's the only one that signs. All right. And then the husband signs, and then the husband signs. And then all of a sudden they both have to sign. And he freaks out. He's like, why is she on here? Why is she on here? And I'm like, I don't know. And it just it destroyed the whole closing because I didn't have a good answer. I wasn't prepared for that. I hadn't done my due diligence. I hadn't pulled the deed and saw what it was. I didn't ask any questions. I didn't know what I was doing. So that hesitation and not knowing was really a problem. And you kind of have to avoid that if you're in the listing and they're like, well, she's not on title, and be like, we like to have her on title. We like to have her sign the contract, even if she's not on title, because we know we're going to want her to participate. We want to keep her involved. Now, there's more to it, you know, that there's homestead laws in Florida, and we probably need her signature if it's possible. So it's really just a practical consideration, get everyone to sign.
Well, and also it's nice to know if there's a family dispute about the sale or purchase of the property.
Yeah.
I mean, I've had more than my share of calls where, you know, that they're trying to get out of the deal. Wife and kids are crying. They don't want you to sell, you know, the beach house property. So if there's a family issue, you want to know up front.
Yeah, exactly. Now,
It is-
the other side of it is that listing agreement or that sales contract. Let's say it only has 2 lines for the seller to sign. Do you have a suggestion, Dad, or Mike? Mike, do you have a suggestion? What if there are only 2 signature lines and there are 3 people that need to sign?
I walked down the hallway and talked to Don.
There you go.
Squeeze them in somewhere.
You squeeze them in somewhere. The important part is that
Anywhere.
they
I don't
sign,
care.
get them to sign. I've even seen, and I like this approach, you just have 2 of the last page, 2 signature pages. And so, because as long as all the sellers signed, even if you have 2, you know, page 12s, just have them on both. So on the first signature page, you'll have seller 1, seller 2, and on the second signature page, you'll just have seller 1. That would work. That would be fine. You know, you could always consider that. We do that with settlement statements all the time. So you'll see, you know, that let's say buyer and seller are signing separately. So you'll have 2 signature pages, one with just the buyers on it and one with just the sellers. Or even more fun, if the sellers are getting a divorce, you might see the sellers on 2 different pages. So you can have duplicitous or, you know, duplicate pages that different people are signing on.
I would apply the everybody sign rule to corporations, LLCs as well, because the insurance company will want that if there's any breadth of a dispute amongst the members or shareholders.
Well, and that's the other thing that I wanted to talk to, Dad. You know, you and I are always worried about the closing table. So you've got who needs to sign the listing agreement, who needs to sign the sales agreement, and who needs to sign the closing documents.
Right.
Potentially they're different answers. And I know that sounds a little
Totally
strange.
Yeah.
But so at the listing agreement, we want, and Mike, I would love your opinion on this. We want the owner of the property to sign the listing agreement personally, like not individually, but like I want them signing it. I don't want a power of attorney to sign the listing agreement.
Yeah.
I want some sort of, you know, separate corporate resolution, you know, where, you know, Joe gets to sign. You know, I don't really want that. I want Mike Hughes to sign the listing agreement, right? Not his power of attorney.
Yeah,
Why?
I'm not comfortable with those because you don't, the more links you have, the more apt you are to have something wrong with one of those links. And for example, with a power of attorney, it could have been revoked. It could have been terminated. There could be some self-dealing involved.
Yeah.
The the attorney, in fact, may be doing something nefarious in violation of the statutes.
Well,
You don't.
and you could even have, like Mike, this is something that you're actually very adept at. You're always worried about what if someone tries to say no? What if they try and back out of the deal later? And all we have is that listing agreement. And one of the arguments is, well, that was my power of attorney and he didn't have authority and I revoked that. I revoked that months ago, right? And you're like, oh my gosh, is my listing agreement worth anything at that point? So
Right.
what I love to do, and I think it's a good business practice, is you have the individual who owns it to sign it. You know, if it's mom and she's elderly and she's not gonna be managing this process, her son is gonna manage it for her. That's fine, but let's have mom sign the listing agreement. And you know, let's make sure the son is involved, but I really want mom to sign the listing agreement. And then I can have her son sign the sales contract and have her son sign as power of attorney on the closing documents. But it's very, very important for me to know that mom agreed to sell. That was the beginning.
I know it's really important to our title insurance underwriter. They want to see, let's say you are exercising a power of attorney on my behalf. They want to see my signature on something so that
Yeah.
there's some indication that I know what's going on.
They do that with mortgages and promissory notes too. I
Yeah.
remember my wife was working, she was doing a 24-hour shift and we were buying a house the next day. So she got home at like 9 o'clock in the morning after 24 hours. And I tried to ask the lender, hey, can I just sign as her power of attorney? You know, she's asleep, she needs to rest. And the lender said, no way. You know, that's not a good enough excuse. We want her there. And they wanted her there because she was the one borrowing the money. They didn't want, you know, her to come back later and say, well, you know, my husband didn't have my permission or something. It's just a good business practice.
Yeah,
Ever
it's
had any
risk
problems like
mitigation.
that, Mike?
Yeah, I got sidetracked for a second because Don had raised something a couple minutes ago. It's very, very relevant, and that is to flush out whether the sellers are really willing to sell. And I get that. Two of my problem cases are divorces, where maybe one wants to sell and one wants to stay in the house and they're not in
Right.
agreement, and yet they come to you and you got to kind of go through that. But the other one is when there's 5 kids that inherit a property and maybe
Right.
3 want to sell and 2 want to negotiate. And so you're kind of in the middle of a family matter, and so you really do need to flush out up front, is everyone in agreement on selling? So that was a
Yeah.
good point, Don.
Thank you.
Well, and so I actually have a closing at the moment, and that exact scenario is happening. And so this is where it gets a little tricky. So that first part of the advice is generally get everyone to sign, you know, at least those who need to sign, but at most, let's get everybody. But sometimes that's going to cause problems. You know, Dad, you and I have talked about stories in our histories where not all the members agreed to sell. Not all the kids agreed to sell, or you know, only the trustee is signing, but the beneficiaries don't want to sell. And that is definitely more complex. So here's the scenario that I'm dealing with at the moment. We have a listing. There was a mom and dad own the property in their trust. They were the trustees, but mom and dad have passed away. And they listed their daughter as the successor trustee. She's the sole trustee after her parents have passed away. And then it lists in the documents that there are 3 kids and they're going to inherit the proceeds, you know, equally. Well, the listing agent started getting a little freaked out, and I thought she handled it amazingly well. But she started getting freaked out because the siblings are not in agreement on 1, selling the place, 2, how much to sell it for, and 3, what everybody deserves to get from the proceeds. It's like a perfect storm of disaster. And so instead of just rushing and having all of them sign and saying, hey, we have to get it all signed, she actually was a little more adept and said, maybe there's more to this. I need to run it by the attorney. So she got me involved. I reviewed all the trust documents. I understood kind of the process and what was happening and who was dissenting. And we were
Right.
actually able to make a determination that there is one trustee who has the sole authority to sell. I don't care about the beneficiaries. I don't care about them. This person has the authority. Now, if those beneficiaries want to sue the trustee, that was something I needed to warn her about, that was possible. But under the terms of the trust, she has the authority, the sole authority to sign the listing agreement, sign a sales contract. Really tricky though, huh, Dad?
Yeah, but you can, the flip side of that, and without getting too personal, when I sold my office,
How is that not too personal?
that's pretty damn personal. You got to remember we're insurance agents essentially, and insurance companies do not want controversy. They don't want to have to analyze a whole bunch of statutes to see whether or not this is legal or not.
They don't want to
So-
underwrite a lawsuit,
So, I mean,
like an obvious
again,
lawsuit.
using myself, I had an LLC and we had other members, and they had the appropriate number of members vote to sell the office. I voted against it. Few days before closing, I emailed the title company saying, I'm not signing anything if you want my signature. That was enough to buy time for me to negotiate what I needed to get. The insurance company did not want to even wonder whether or not I had a valid cause of action against anybody. So
Yeah.
yeah.
Yeah, and that's what we have to worry about. Could they close and hold money in escrow? I actually am doing a deal right now for the Bahama Club, which is here in Naples. And they're selling the entire building for a huge amount of money to a big developer. And they're having to go through each one of the owners and negotiate individual deals because collectively they can't agree to something. They can't get everyone to be on the same page. It's complex, but it's doable. And I think in those very complex situations, you want the attorney to be involved. You probably can't make a decision over the weekend on whether you can sign this or not. It's going to require a little bit more. And so that kind of leads to the main point of this topic is, well, let's think about how people own property and what it is that they actually own. In the Bahama Club, for example, it's actually a co-op. And in a co-op, you actually own shares in a company that then owns the real estate. You don't own your unit. You own shares in a company. It designates like a sole possessionary rights to unit 101. And you actually own like 2.5% of the total company.
Yeah, you get a sublease too.
You have a sublease that's part of it, exactly. It's similar to a timeshare. Timeshare is even smaller. You own rights to 1 week a year, or 2 weeks, or 10 weeks, or whatever it may be. And then you've got condos and you've got single family homes, obviously. Buyers and owners of property, they're going to do different things, and it changes. Dad, you were doing some research this morning on, LLCs, S corps, trust, foreign corporations that own the LLC for tax purposes. And the thing that stuck out to me was every couple of years that landscape changes drastically because the laws change and what people are going for. Can you kind of explain, like you mentioned S corps used to be a big thing and now they're kind of less.
Well, we always used S corps, but there's limitations on who can be a shareholder in S corps. It had to be an individual, it had to be a US individual. So you couldn't use corporations, you couldn't use offshore corporations, you couldn't use non-residents as shareholders, and there's a limit in the number of shareholders you can have. So, for years they came up with a thing that was a blend of corporations and partnerships, and they called them associations. Ultimately, in '82, they statutized that and came up with LLCs, which allows for the members to be corporations, US, foreign individuals, so that people from other countries or people who just want to keep things anonymous can acquire title and have the same benefits of an S corp, which is a flow through of the taxes. That's the real benefit. You get taxed as a partnership and you get the safeguards, the legal safeguards of a corporation. So it's a hybrid. The LLCs, you can have more shareholders, unlimited shareholders, Liechtenstein entities.
So
Dutch-
you mentioned the Liechtenstein. We actually had a Liechtenstein corporation a couple of weeks ago. We have a Liberian corporation currently.
Right.
That it's pretty simple to explain why people do those things. Taxes, right? They're trying to
They're
avoid
evading
taxes.
taxes in their home country. In Liechtenstein, they have Anstalts and they have bearer shares and in numbered accounts. So you can just give the share to Joe Blow and he is now the owner of that account.
Yeah.
I mean, that's
Which
what we
makes
did a lot
listing
of.
agreements super fun. So
It's
you're
fun.
what you're gonna do in those scenarios is first you're gonna pull the deed from the county website and you're gonna look at who owns the property. And I'm going
Right.
to recommend you do that before you meet with the owner of the property or the person that you're gonna meet to sell the property with. You have to have that deed because when you sit down and they say, well, we'd love for you to sell it, you have to be able to ask that question. What is this Liberian corporation, by the way? What is this? And they should have a good answer. Like, oh, that's the company I set up as a tax haven because in Canada they were charging 65% tax rate. In Liberia, they charge nothing. It's like, oh, well, what documentation do you have? Because I'm going to need to make sure that I have you signed correctly. In fact, in that scenario, the true owner of the property is not on the board of directors. He's not the president. He doesn't have signing authority. He actually has
Totally anonymous.
He's totally anonymous.
Yeah.
And so that also leads the anonymity is something that we see with land trust. Dad, that's a statutory thing that kind of promotes anonymity. Can you explain a little bit about land trust?
Well, it's that statute 689-071-073. Florida enacted this years ago.
Mike, what was that statute number?
689.071 is the land trust. And it allows the trustee to keep the beneficial interest confidential. In 073, it gives the language we see on deeds where the trustee has the power to mortgage, encumber, convey, and otherwise transfer the property. And they usually cite the statute. That allows people to keep the terms of their trust confidential. For example, if one of the owners is a Rockefeller, they don't want to disclose the terms of the John D. Rockefeller Trust. And I've had that happen. We've represented one of the Rockefellers.
You're
So,
not supposed to tell them that. Oh my goodness.
well,
All right, let me show you a
like
land trust agreement. So this is a template. There's nothing specific for any one of my clients or any of that, but basically it is it's on paper only. It's not formed with the Secretary of State. No one knows who the beneficial owners are. And so we actually had a question that came up yesterday on this because this person had heard that you might get some tax benefits to a land trust. And they weren't talking about income taxes, they were referring to property taxes specifically. And so I'm here to somewhat debunk that, a little bit at least, but the Florida Land Trust Agreement, this is a standard template. It basically says, that the beneficiaries control the trust. The beneficiaries control the trustee. So you can name any trustee. Dad, you've been named as a trustee on dozens of land trusts over the year. And you don't own anything to do with the property. You have no liability for paying taxes or doing any of those things. You work at the behest of the beneficiaries. If they want to fire you or remove you, they can do it instantly.
Right.
So, but it maintains their anonymity. You can call the trust anything you want. You could call it the Mike Hughes Land Trust and list Mike Hughes as the trustee. And hey, by the way, Mike, you don't own anything about that trust.
That's not fair.
It's not fair. I agree. Totally unfair.
We could name Mike a trustee of anything. Wouldn't that be fun?
Wouldn't that be fun? Give him a job to do. So what the question that came up yesterday was, all right, I've heard that you could use a land trust to avoid the increase in property taxes. And I know you're on there. I know you're out there. So if I'm not answering your question specifically, I'm sorry. But I thought that this is what it was about. Let's say I own the property and I'm the seller. So I'm, Christian Ross. The buyer is Mike Hughes. And Mike says, all right, I'll buy it from you. I'll pay you $1 million. Let's make it 2 million because I'm a nice guy. So Mike gives me $2 million. I sell it to him, and Mike, you create a land trust, and it's called Christian Ross Land Trust.
This way Ruth doesn't find out.
It's so no one finds out. And it also is so that the tax appraiser doesn't find out either. The tax appraiser just assumes, oh, Christian put it into his trust. He's doing some sort of estate planning. And we're going to avoid any sort of, there's no sale. Obviously there's no sale. And, we're going to skip all those tax, things, because typically what happens, my tax bill is nice and low. Mike goes and buys it. Now the county's going to reassess and they're going to charge him top dollar. Well, he doesn't want to pay top dollar. That, no way. He wants a nice low save our homes exemption or whatever it may be. You know what that is, Mike? That's fraud. Don't do that. You're not supposed to commit fraud. It is fraud. If the county finds out, you would be nailed to the cross. It would not be good. And so it is something that people do. They also do it potentially to try to avoid the existing lender finding out that there was a sale. Mike, have you ever heard of
hotline number on the appraiser's website for this, Christian?
Yeah, so your neighbors tend to be the number one person that reports you. Your neighbor reports you. So be careful who your neighbors are. I think that's why Mike has so much acreage around him, so he doesn't know his neighbors. Definitely a better thing. Aren't you glad you came on today's video, Mike?
I walked right into this one.
So
Sorry, Mike.
Online, there's a lot of bad stuff out there on the internet, and someone might say that about this YouTube video someday. But there's a big craze these days to use land trust to commit some sort of fraud, so either mortgage fraud or tax fraud or something like it. And so another thing they do is, you want to take advantage of my nice low interest rate on my mortgage. And so he calls it the Christian Ross Land Trust and hopes that the lender doesn't find out that there was actually a sale, so that you can maintain my mortgage and not have to, get your own. It's called a subject to purchase. And they're in violation of the loan documents. It puts the seller at a huge risk, because I'll tell you from my perspective, if I'm the seller, I'm still personally guaranteed on that loan, but I have no control over the house. All Mike gave me was my equity. So it's
Plus
a really
the doc stamps you're supposed to be paying. I mean,
you're supposed to be paying doc stamps, and you're supposed to be paying off the mortgage due on sale costs. It's pretty ugly. So people use these types of entities for any number of reasons. Usually it's taxes or it's a partnership. So Dad, what are the downsides? Let's say you and I buy a piece of property together, and we put it in our names individually. What could happen that could kind of cause problems with our partnership, right? There's a million things on title.
Well, I mean, anytime you deal with family and money, that's touchy. So you want to be. I mean, I did this with my dad when we bought real estate on Marco together. So
were you guys on title together?
We were on title together individually, and I knew that most of my assets were protected anyways. They're either homestead, pension plans, or estate by the entirety with your mother. So if somebody got a judgment against me individually, they couldn't levy on the things held as an estate by the entirety with your mother.
Right.
So
I mean, and luckily,
they could take my clothes and one of my cars, and that's it.
So this is a great example because, things happen, like you said, you could get in a car accident, you could paying your credit card bill, you could have a tax judgment against you. And any one of those things could cause a problem if you were to try and sell that piece of land. And it could impact your partner, right? It could impact the person that you were buying.
Impact you. You got to really be careful if you're doing business with family.
Well, and this is for anybody. So you have the experience doing it with family, but the risk to partners buying real estate together is very real. So they will use an LLC or an S Corp or a C Corp to do it. so that any personal judgments wouldn't attach to the real estate itself. It might attach to your ownership of your company, but not to the real estate. So,
Yeah,
you know,
they
hypothetically,
catch up with you after the judgment's rendered with the post-judgment discovery. when you
which,
have to-
yeah, which is fine because it doesn't affect your partnership, right?
Right.
Your partner is over there. Your divorce doesn't, you know, affect or impact your partnership. Your tax judgment doesn't affect your partnership. And we used to do that when we were buying subdivisions and doing commercial deals, is that we can't afford to put our partners at risk if we have something that goes wrong in our business. So we have to separate it out, because otherwise we'd get sued for, you know, negligence or, you know, malpractice of some sort by putting them at risk. So people will do a partnership because they're college buddies buying a condo, or they're wanting to do rentals,
Yeah.
some sort of limit of liability. It's
The thi-
complex. It
The
obviously
thing with my dad, Christian, it was raw land, so I took that into account. We weren't renting the place. I wasn't worried about people tripping down the stairs.
Yeah, you
So
guys, it was, you know, there was a risk there and you were willing
there
to
was a
take
risk.
it. And you were willing to take it. But I think if
There's a
we were to
minimal
give
one.
someone advice, don't do as we do as we say, right?
Yeah.
Isn't that easier? You know?
Yes, like we told you when you were little, right?
That's right. So, you know, there's a lot to it. And I guess the lesson on that stuff is there's a lot of information online. There's a million different ways that people do things, but you got to do your own research as to why. You really have to, because what would have been good for someone that was putting all this together 10 years ago no longer makes any sense, because tax rates have changed and the loopholes have changed. So you got to do your own research. You can't just assume, well, because that's the way he did it and he's successful, that it must be okay for me. You have to be relevant. You have to be present with the latest offerings.
Well, the additional thing that people over 60 worry about, if like you and I buy something together, at some point you're going to think I lost my mind, and you're not going to approve of me wanting to sell and buy a Harley and go skydiving or do whatever crazy thing I wanted to do with that money.
Yeah, well, and so it's a good transition. Mike, have you ever heard of a ladybird deed?
Yeah, Don's brought that up every now and then, but I really don't know the particulars on them.
So another term for it is called an enhanced life estate. So I honestly felt like this was something that I would only see in law school, because for 10 years after law school, I'd never even seen it, not once. So life estates in general are when you're giving someone the property to use during their life, but upon their death, then it goes to someone else that you designate. Either it goes back to you or your estate. It could go into a trust, or it could go to your kids, whatever it may be. So that's a typical life estate. And under most life estates, I would need not only the life estate holder to sign off on a sale, but also the remainder men, the people that were going to receive it upon that person's death. So if you pull up just a general life estate deed, you're going to need everyone to sign. Everybody. And again, it goes back to what we were saying before, better to be safe than sorry. But there's another type of deed out there called a ladybird or an enhanced life estate. And this is actually a really cool estate planning tool for what, Dad, you just said.
Yeah.
You want to be able to do your estate planning, but not be told by your kids that you're making a bad decision and I won't let you sell, right? That I think you used to say, like, it's my house until it's not.
Well,
so,
I mean, there's at least two of your siblings who would have me committed in about 5 minutes. So,
am I included on that? I don't know.
no, it'd be
no.
your sister and one of your brothers.
So an enhanced life estate is very cool. It is very similar. Mike, have you ever done you ever seen on because you're a banker at one point in life, where you would have a bank account and you can set up beneficiaries?
Yep.
Okay, so an enhanced life estate is where you're setting up beneficiaries. So on a bank account, you know, you and your wife own the bank account, it's your money. But if something were to happen to the two of you, then it goes to your children and you list your girls as the beneficiaries. But in the meantime, the girls have no ownership in your bank account. It doesn't give them access to anything. They don't have signature rights or any of that. They're strictly beneficiaries. That's what an enhanced life estate is. It is my property during my life, and then it is payable to the remainderman. But in the meantime, and this is the enhanced part, in the meantime, I can sell, mortgage, convey, gift, remove the life estate, whatever I want to do during my life.
Quick claim it back to yourself.
Quick claim it back to myself, whatever I want to do. And that's the enhanced. It is one of the coolest estate planning tools that I've used. We're probably doing 1 or 2 every week.
You do it with somebody who's terminal typically.
Well, you could do it with any, like I would say, you're obviously going to wait until your kids are adults. This is not something that you do when your kids are minors, or if
Right.
there's any sort of substance abuse or any other weird things. But if once you're okay with your kids inheriting the property upon your death, the enhanced life estate, it really can't be beat. It doesn't go through probate. It goes automatically to your children. It's a lot cheaper than setting up a trust. You know, the trusts have more features. They can do a lot more with a trust. But if you're at the point where you're willing to just, yep, they get it when I die, it's pretty great. Dad, what do you do? Let's say mom and dad have passed away. It is an enhanced life estate or a ladybird deed.
Right.
So mom and dad passed away. You're talking to the 2 siblings, the children. Right. What do you need from them to have clear title? Who would you have sign?
Death certificates for mom and dad would have an affidavit that they owned it continuously from that point to their date of death. And then from the 2 kids, obviously deeds from them and homestead language. If it's not homestead, dictated it. If it is homestead, we'd need their spouse.
Yeah, and so that's what we would do at closing. For the listing agent, you would just have the 2 kids sign, and you would tell them, hey, do you have the original death certificates? You'll need it for closing. Let's set up a conference call or an email with the attorney and just double check everything. But yeah, you'd have the kids sign.
But all this presumes that your children are old enough to handle the money, that they're not going to go out and blow it in 5 minutes and make their life worse off for it. So, you know, I mean, I used it recently for my sister, you know, that she had adult children, they could handle the money. If you were in your 20s, that's not the way I personally would handle it.
Well, and it causes some problems. The one problem I would foresee is that you're giving equal shares or even unequal shares of the real estate to different people, and not just one signatory, right? So you're not just nominating one trustee. In that case, you're putting down all the beneficiaries. Right. So you'd have to have all the beneficiaries to work in concert to be able to sell the property.
They have to work together to sell it. And if they don't work together, then you get into a partition situation where you're suing your sibling.
And that's pretty awful. Where, you know, the last thing that we would more commonly see is probate. And I think the big thing with probate is it's really not as bad as most people think it is.
Yeah, I don't have a problem with it. I honestly don't. I mean, if you're leaving a significant estate behind, you don't arrange the whole thing to avoid, you know, $10,000 or $20,000 worth of probate fees.
Yeah,
you know,
and that's a pretty expensive probate. I would say most people it's going to be $5,000 or
yeah.
something.
It's my old boss in Miami. It's like having the tail wag the dog. I'm more concerned about, you know, if you need a trust, you know, maybe you have a special needs child, maybe you have somebody who's in a bad marriage or has a history of bad marriages.
Yeah,
in those situations, or they just don't know how to handle money. You think it's going to ruin them if they get a whole bunch too fast. Yeah, you might want to, you know, parse it out over a period of years.
So in a probate scenario, you know, let's say mom is on title, she's just recently passed away, and now it's in mom's estate. And right. you look at the will, and it shows that the 2 kids are, you know, they're the sole beneficiaries and they're the personal representatives, and so you just assume, all right, well, I'll have them sign. But it's not always like that. Typically, what you'll need is that will has to be probated. And probate is just the term used to validate the will or validate that there is no will and nominate and appoint a personal representative. So they have to have gone through probate if the person who's on title has passed away. They just
Well,
have
and
to.
the underwriters want an order from the judge stating that it is in fact homestead and that any creditor claims do not attach. If you have a bunch of medical bills and things like that, the underwriters are going to insist on that.
And it's complicated, I would say. What I typically counsel people in is like realtors, I'll say, ask for the probate documents so that you can send it to the attorney. And it's that simple.
For people, I tell them the insurance company really has a huge role in this. It's not just what the statute says, they want to mitigate risk, so they're going to ask for a lot of things that technically might not be legal.
Yeah. Hey, Mike, before we sign off, do you have any other words of wisdom for realtors and how to kind of operate in this little minefield? You know, how do you validate who signs, and where do the problems come from?
Which problems do you want to hear about?
Yeah, exactly. We're getting a whole host of them.
Hey, Chris, we got a quickie question from Jackie here about ladybirds, and does the HOA, do you need HOA approval of an owner? And I'm assuming
Typically
that
you don't, Jackie. Typically you don't need any sort of approval because the children that are listed or whoever is listed, they're not on title as far as an ownership. They're just
don't
a
own it yet.
beneficiary.
They don't own it yet.
They're essentially on the will. That's kind of how it looks. So we don't normally, you are not going to need any sort of HOA approval or condo approval. But
Good
Mike,
question.
do you have
Right.
problems? Do any of the, where's the bottleneck on some of this stuff? Is it when you don't have the documentation? Is that where the bottleneck tends to be?
You talking to me or Michael?
Mike.
I was thinking about something else. What was the question again?
Yeah, so like in your office or in any broker's office, is there a bottleneck on this stuff? Like how can an agent be better prepared to get the right people to sign and to get the right documentation for a listing?
I mean, honestly, internally, it's a matter of, we get a lot of agents that join the company, and everyone has a different learning curve on the system because they came from another company with a different system. So it's really learning the system, because if they send a listing in to get it signed and they send it to the wrong person's email, that person might not see that email for 5-6 hours.
Yeah.
Then they end up forwarding it. So it's understanding the internal system. And believe me, I love suggestions on how we can improve it. So if someone has good suggestions, we'd love to listen to good suggestions.
Yeah, and the other thing that I really love is getting your documentation. And so if you, instead of asking multiple times, or instead of forgetting to ask and then having to go back multiple times, just ask for everything. So, that's again, it goes to what my dad was saying, that, have everyone sign. Well, ask for everything. Get a copy of the probate documents, get a copy of the trust, get a copy. And you don't always need it, but it's more painful to have to go back 100 times to ask for it. Just ask for all of it up front. Give me everything you have. Whatever you have, give it to me. I'll make copies. I'll keep it in my system. And if my broker requires a certain document or something, I'll at least have it. I'll know that I have everything. Awesome.
Do you guys ever get any issues with electronic signatures on these documents? Anything jump out at you?
No, not really. Anything that is, has to be witnessed and notarized, we typically want that in wet ink. We want that done in person. But if it's like a sales contract or a listing contract, then electronic is fine. It falls within the Electronic Reporting Act, or I can't remember exactly what it's called.
The challenge of the
Jackie
city
has
is
another
senior
question.
citizens. Sometimes they struggle with that a little bit.
Yes, you guys are a big problem.
Yep, exactly.
Chris, you see Jackie's question on the ladybird again? She has a new one.
Go ahead. Let's see. Can you use a ladybird in addition to a trust? It's already in place for a family. So Jackie, you can do anything with a ladybird deed. You could do it where my wife and I own the property for our lives and then into our trust at our death. You could do that, no problem. Typically what I'll see is, let's say you're divorced, but you've met someone and you've been in a long-term relationship. And so you'd say, all right, I want, if I die first, I want my girlfriend or fiance to be taken care of. I don't want her to have to move out of the house, but I also don't want to put her on title. So what they'll do is they'll give a life estate to both of them during their lives. And then upon both of them passing away, or the last person passing away, then it goes into that person, the original owner, the guy who paid for it, the girl who paid for it, goes into his or her trust or his or her estate, or to his or her kids, and not, just into the girlfriend's name. So that is a really efficient thing. It gets tricky when you consider homestead rules. Homestead in Florida has some sticky tentacles when it comes to married people and the homesteaded property. So that can really add to that
Well,
dimension.
a lot of people like myself, Christian, will have revocable trusts, and that'll handle all the family stuff. Well, who gets what and when. And for myself, I might use a Florida land trust agreement if I'm doing a deal that involves you and maybe personal friends of ours who are non-family. So it just might be easy for an isolated deal.
I think the lasting piece that I'll give is that, number one, I think anonymity is overrated, I think people think about it a little too much. They want to hide who they really are, and by doing that, they cause a lot of complication in their lives, unnecessary. The reality is, not many people care what you own or don't own, unless it's like a very public thing. If you're a very public person and you just want to maintain that privacy, but that's a very small piece of the population. I had a client once who had a stalker, and that obviously required some anonymity. But the problem in that case is, if you're getting a mortgage, there is no anonymity. There just isn't. It can be really struggling. It can be done, a land trust with a mortgage. It can be done, but it's challenging. So you got to be thoughtful about it. And Dad, this was something you and I talked about before, and I'll end with this. The NABOR standard and as-is sales contracts are assignable by the buyer without the seller's permission,
Right.
as long as it's outside of 15 days of the closing date. So just if you're on a weekend and the buyer is unsure about how they want to take title, do they want to use a dynasty trust or a land trust or a corporation or a British Virgin Islands company, just do simple now, and then we'll assign it later. We've got a big deal going on right now. It's in the guys.
You want to get them while they're excited about the property, and you just point that clause out in the contract, and they can deal with it later.
And then on FAR there's a checkbox. You can choose whether it's assignable or not. So just make sure that if you're going that direction and the buyer wants a little bit of flexibility, that the checkbox saying it is assignable is marked. Well, thank you. That was actually kind of fun. It had a lot. Had a lot there. So if anyone has questions about ladybirds or life estates or some of these other things, if they have a listing, that's kind of what we thrive on. Contact us directly, and we can kind of get you some information before you go and market the property for sale. Thank you, Mike. I appreciate it.
Thanks, guys.
I know.